Think your facts are private? Maybe they are, maybe they're not. Let's take a look at what private facts are by determination of the court and see whether or not we actually have a right to keep our facts private. So private facts are highly embarrassing pieces of information. They may not be newsworthy at all. They also can't be obtained from the public record. So remember how many things are public. Your home address, how much you pay in property taxes, who holds your mortgage, and the ins and outs of your home. It could be your salary. There's a lot of information that's out there in the public sphere, but when we're looking at this information, it is private. These are intimate facts that somebody may not want a community to know. It could have to do with things that have nothing to do with legality or even being reprehensible behavior, but just things that you would like the community not to know about you. It could be who you owe money to or how much, any affairs that you may have had, situations like abortion or past incidents of drug usage or addiction, hair replacement treatment, anything that you feel is a personal, private fact about yourself that you choose not to share with the community. Now the question is, are all facts private? And in fact, we have a pretty noteworthy case that addressed that very thing related to this gentleman right here. His name is Oliver Sipple, and he saved President Gerald Ford from an assassination attempt in San Francisco. Now, he was a former Marine, quite heroic in his endeavor here. He was also gay, and the newspaper revealed his sexual orientation, and he sued. And the question is, did he win? Now, I want you to think about that for a second as to whether or not the revelation that someone is gay in the 1970s would have harmed their reputation, would have been a fact that they would like to keep private for whatever reason, and whether or not they have a legal right to keep that information private. Now, there, of course, are more circumstances at play here, and we'll check those out. Now, when we look to make a determination as to whether or not we're going to reveal something that is private, we have to look at newsworthiness to a great degree, because that is a defense if we do get taken to court for revealing private information. So situations related to crimes, if you have been the victim of a crime, that actually is public information, and it's information that is able to be publicized. Suicides are crimes, so if someone that you love or God forbid you commit suicide, that is public information as well, and is absolutely within the purview of the media to publish your name and the circumstances. Divorce, also public. Often disease can be public, especially if it's something that is deemed to be in the some type that could present harm to the public. Now, we're usually really careful about that, and of course HIPAA has allowed quite a bit of restriction on health issues, and that has made them even more private, but that doesn't mean that we don't have access to things. In catastrophes, so people who, were in the midst of Hurricane Katrina or Hurricane Sandy or in Haiti, a lot of privacy is lost when disaster strikes. And of course, if you're involved in an accident in some way, then that becomes public information. The question, of course, though, is how personal is too personal? Now, we're looking at First Amendment defenses in relation to privacy. We're going to focus first on these two. One is public significance, and the other one is information that's lawfully obtained, and they're similar in their circumstances. The one on the left, the Florida Star versus BJF, had to do with a newspaper, the Florida Star, which published the name of a rape victim that it had gotten from a police report. Now, the rape victim sued and said it was an invasion of her privacy for her name to be published. She was awarded damages because there was a state law that said it was illegal to print the name of a rape victim. But on appeal, the Supreme Court actually ruled that information that is obtained from the public record to inhibit that publication is a violation of the First Amendment. So because this information was in the court record, then it was open to be published. Similarly, in Cox Broadcasting Corporation versus Cone, we had another situation where we had a young woman who was sexually assaulted at a party. She later died, although there's some question as to how she died, but the media was pretty much all over this story and published her name, and of course, because she had died, they were more likely to publish her name than they may have been had she been a living rape victim. So her father ended up suing the Broadcasting Corporation, WSB was the call station, and its reporter for publishing his daughter's name. And he said that it violated Georgia law and the right to privacy. So initially the trial court granted a judgment to him, but on appeal, this Georgia Supreme Court dismissed their claim, and the Supreme Court ultimately ruled that the statute in Georgia that prevented the publication was a violation of the Constitution's First Amendment. Now, the public record is often a defense that's put up against privacy claims. If something is in the public record, then it simply can't be susceptible to a privacy claim. It is, by definition, public. And the passage of time, so recognizing that newsworthiness doesn't really disappear over time, and, facts and people who were newsworthy stay newsworthy. So even though someone may have been newsworthy in the past and then they move on to another aspect of their life, say a criminal who gets out and goes to conduct their life, that crime is still in the public record and is certainly still open to be reported upon.